Welcome to the USDA Civil Rights Requirements Training. The objective of civil rights are to ensure equal treatment and access for all applicants and beneficiaries, to provide participants knowledge of their rights and facilitators knowledge of their responsibilities, and to eliminate any illegal barriers that prevent or deter people from receiving benefits. Civil rights regulations are intended to assure that benefits of the child nutrition programs are made available to all eligible participants in a non-discriminatory manner. All sponsors receiving federal funding must implement civil rights requirements to be eligible for the program. The FNS 113-1 instruction applies to these programs: the National School Lunch Program, the School Breakfast Program, the Special Milk Program, the Summer Food Service Program, the Food Distribution Program, and the Child and Adult Care Food Program. Classes protected under civil rights policy include race, color, national origin, sex. This includes gender identity, expression, and sexual orientation, age, and disability. The USDA also prohibits discrimination in the child nutrition programs on the basis of marital or family status, political beliefs, parental status, protected genetic information, and whether an individual's income is derived from any public assistance program. To qualify for federal financial assistance, any parties entering into contracts involving the use of federal funds are required to include assurances that USDA civil rights requirements will be upheld. This is included in the permanent agreement contract required by RIDE upon becoming a sponsor, and it is certified on an annual basis by the sponsor during the renewal application process. Prescribed language must be included in all contracts, MOUs, and MOAs, including during contracts with food distributors, with contracts with food service management companies, and between vended meal contracts between SFAs. With the exception of retailers and vendors, the agreement must state that the entity involved will compile data, maintain records, and submit reports as required to permit effective enforcement of non-discrimination laws, regulations, policies, instructions, and guidelines. This agreement permits authorized USDA personnel to review such records as needed to ascertain compliance. So the USDA provides us, the state agency, policies, regulations, and guidelines around civil rights. We, RIDE, the state agency, then try to deliver that to you, the local agency, in the form of trainings like these. And the expectation is that you, the local agency, will ensure that all of your frontline staff is provided with civil rights training, no matter what role they play in the child nutrition programs. The SFA's responsibilities for civil rights training include the following topics: collection and use of data, effective public notification systems, complaint procedures, conflict resolution, compliance review techniques, resolution of noncompliance, requirements for reasonable modifications for persons with disabilities, requirements for language assistance, and customer service. These are the required elements of civil rights training. For some staff, only some of these elements will be a big part of their role, but all staff should be receiving training on all aspects of these civil rights compliance. The first element of the civil rights training that needs to be covered is the collection and use of data, specifically the obtaining of ethnic and racial data. The screenshot pictured here is from the meal benefit application, or the household application that is completed on an annual basis and submitted to the SFA. This section is for the household to identify their racial and ethnic data. As you can see, this is an optional part of that form. Sometimes people do feel like it's unnecessary or uncomfortable or too personal to be disclosing this information, especially if they're filling out like a plethora of forms. They might wonder why. It's the SFA's job to try to make this make sense for households and families, just so that they feel more comfortable knowing that the data is ultimately collected so that it shows at an aggregate level like how well each of these programs are reaching different ethnic and racial populations. Data may be used at the national level to aid in establishing the validity of civil rights complaints, and may be used at the local level to identify additional resources that may be needed for potential program participants, which we'll talk about later in this presentation. If for whatever reason a household chooses not to provide ethnic and racial information, you can use the following methods as a last resort: visual identification, or personal knowledge, records, or other documentation your district possesses that identifies household or ethnic or racial data. There are two ethnic categories: Hispanic or Latino, or not Hispanic or Latino. Someone who is Hispanic or Latino may be Cuban, Mexican, Puerto Rican, South or Central American, or another Spanish culture or origin, regardless of their race. In collecting or providing racial data, a participant may fall into one or more of the 5 racial categories: American Indian or Alaskan Native, which is defined as a person having origins in any of the original peoples of North and South America, this includes Central America, and who maintains tribal affiliation or community attachment. Asian, a person having origins in any of the original peoples of the Far East, Southeast Asia, or the Indian subcontinent, which includes Cambodia, China, India, Japan, Korea, Malaysia, Pakistan, the Philippines, Thailand, and Vietnam. Black or African American, a person having origins in any of the Black racial groups of Africa. Native Hawaiian or other Pacific Islander, a person having origins in any of the original peoples of Hawaii, Guam, Samoa, or other Pacific Islands. And white, a person having origins in any of the original peoples of Europe, the Middle East, or North Africa. The second civil rights training requirement is an effective public notification system. All FNS assistance programs must include a public notification system. The purpose of this system is to inform applicants, participants, and potentially eligible persons of the program availability, program rights, program responsibilities, the policy of non-discrimination, and the procedure for filing a complaint, which we'll go through momentarily. Required methods of public notification. The public release. This is issued on an annual basis by RIDE on behalf of all existing NSLP, CACFP, and SFSP sponsors. New sponsors and sponsors operating CEP or Provision 2 are responsible for their own releases. Posting the And Justice for All poster. The most current version of the poster must be placed in a conspicuous customer-facing area. Other methods of public notification. These include flyers, brochures, and radio ads. SFAs should also have school nutrition program information available somewhere on their websites. This should also include the procedure for requesting meal modifications, which we'll talk about shortly. Remember, any materials referring to USDA-funded programs must contain the most current version of the full USDA non-discrimination statement. Including program information on public-facing websites is an important component of ensuring that program participants and prospective program participants are fully aware of the program benefits. For new sponsors and SFAs participating in CEP or Provision 2, the public release must include information on program eligibility, benefits and services, availability, applicant rights and responsibilities, procedures for filing a complaint, non-discrimination policies, and any program changes like the changing of a meal site location. Please provide this information, including web-based information, in alternative formats for persons with disabilities. All sites participating in federally funded child nutrition programs must display the USDA's non-discrimination poster in a prominent area where participants and potential participants have access. The poster must be posted at every food service site, including in each cafeteria where meals are served and at any approved alternate serving locations. This is not a necessary requirement for every classroom participating in breakfast in the classroom. Sponsors may also consider hanging posters in additional locations, such as in the office where free and reduced eligibility determinations are made. Posters must be in the 11 by 17 format, and replacement posters can be obtained through RIDE because local reproduction of these materials are not approved. RIDE needs to be contacted for replacements. The full USDA non-discrimination statement must be included on all vital program documents that refer to the USDA food programs. Vital documents include information regarding the availability of program benefits, including benefit decisions and the right to appeal. The full non-discrimination statement must be included in a font that is no smaller than the smallest font found throughout the document. Examples that require the non-discrimination statement in reference to those vital documents include free and reduced meal benefit applications, parent and student handbooks, employee handbooks, and broadcast advertisements. Note that each of these documents should contain information regarding the availability of program benefits and would therefore be considered vital program documents. Please check to make sure that the updated non-discrimination statement is being used. Most currently, you can tell the difference of the newest non-discrimination statement because it includes beyond gender identity, including gender expression, sexual orientation, disability, age, etc. In rare circumstances, the shortened statement tag for the non-discrimination statement, which is "This institution is an equal opportunity provider," may be used. Currently, the shortened tag is approved only for the use on menus in Rhode Island. Please feel free to contact us at RIDE for approval before using this tag in place of the full non-discrimination statement on any other program documents. For the website notification, There are some specifics around how the non-discrimination statement needs to be posted and visible. So the statement needs to be on the first page where the school nutrition programs are mentioned. The full statement needs to be there. It can be pasted directly on the page or linked, but if it is linked, it can't be linked to a closed document. It has to be linked to a web page that would just open in a browser but should not link directly to the USD's website. So to make it easier on you, we have posted the link to our site where we try to keep the USDA non-discrimination statement as up to date as possible, or I'd recommend you just posting the most up-to-date version directly on that web page. Non-discrimination in images. So when using graphics, select those that reflect diversity and inclusion. The third element in our civil rights training is complaint procedures. So SFAs and institutions are required to develop and implement a written procedure to handle any discrimination complaints that may be received. Civil rights complaints are those that allege discrimination has occurred in violation of one of the protected classes we discussed before. Discrimination occurs when an individual or group of individuals is delayed benefits or services, denied benefits or services, or treated differently than others to their disadvantage, and given disparate treatment. So if someone has a complaint, they may choose to contact the USDA directly. They can also contact us, RIDE, directly, or they can notify the SFA of their complaint. Be assured that all conversations involving potential civil rights complaints are documented and that both parties understand the result of the conversation, specifically whether the intention is to file a complaint or to not file a complaint. Remember that SFAs must file complaints on behalf of program participants when they're asked to do so. SFAs and institutions must forward all discrimination complaints received regarding child nutrition programs to a RIDE nutrition program specialist immediately, but no later than 5 working days after the initial complaint was received. The procedure for filing a complaint. It starts with the right to file a complaint. Any person alleging discrimination based on one of the protected classes has a right to file a complaint within 180 days of the date of the alleged discriminatory action. There are certain circumstances where an extension to the 180-day rule is allowed. Secondly, is acceptance. It is the sponsor's responsibility to accept the complaint, written or verbal, which requires the collection of certain information. Once a complaint has been accepted, it is then forwarded to the appropriate officials for processing. How to handle a complaint. You may choose to use a complaint form that either you develop, or you could use the one pictured here, which is the USDA's discrimination complaint form. I can appreciate this form because of the Privacy Act information and informing complainants of their rights immediately, just so that doesn't get lost in the shuffle. Enter the complaint in the confidential log. Confidential meaning the access needs to be limited only to those who need it for their job functions. Then you're going to refer the complaint to the sponsor's civil rights contact person, and then they should be reporting the complaint to RIDE within 5 working days. Sponsors are encouraged to maintain a civil rights binder with the following sections. The sponsor's civil rights complaint procedures, their written policies and procedures about how to accept a complaint, what to do next, and how to document appropriately. Then there's the civil rights complaint log. That log needs to be dated and kept for 3 years plus the current year, even if no complaints have been received in that time. Next, copies of civil rights complaint forms if you're using those. Sponsors should also maintain an information sheet that identifies the civil rights coordinator for the sponsor at the time. And civil rights complaint logs must be maintained separately from operational complaints to ensure confidentiality, and access to these records really should be limited. The fourth element of civil rights training is conflict resolution. Many complaints arise from misinformation, misunderstanding, or poor customer service. So SFAs should gather as much information as possible and work closely with participants in an attempt to resolve any identified complaints. The USDA recommends conflict resolution at the lowest level possible. The following techniques may help when attempting to de-escalate a potential civil rights complaint: remaining calm and asking more questions about the situation, repeating the complaint back and making sure that you understand the complaint, and then trying to help those involved work out their differences. Remember, though conflict resolution is encouraged, an SFA should never discourage an individual from lodging a civil rights complaint and must make complainants aware of their rights from the beginning. The fifth element of civil rights training is preparing for that compliance review. So when we are looking at compliance of civil rights, we want to make sure that students aren't being separated based on any of the protected classes or based on student eligibility status, which can happen in these areas: meal times, seating arrangements, serving lines, eating areas, and meal options. On the right, you'll see a checklist pictured from the Civil Rights Training Manual that just goes through everything we look at when on review in terms of civil rights, and we'll continue to go through the rest of these throughout this presentation. The sixth element of civil rights training is resolution of noncompliance. Civil rights findings identified during an AR or through the on-site monitoring process, which happens through you, the SFA, require a corrective action plan that ensures compliance with the FNS 113-1 instructions. A detailed plan of corrective action must be submitted and accepted for each civil rights finding. Failure to respond or correct a finding may result in the suspension or termination of financial assistance. You can use the Civil Rights Assessment Checklist from the previous slide, along with the monitoring forms, to check compliance. The seventh element of civil rights training is reasonable modification for persons with disabilities. The federal regulations listed are what we'll be referencing in these upcoming slides. Disability can be defined as a physical or mental impairment which substantially limits one or more of the major life activities. The ADA Amendment Act of 2008 expanded the existing definition to include major bodily functions. So these include issues that affect the immune system, digestive, bowel, and bladder functions, neurological, brain and respiratory functions, circulatory, cardiovascular, endocrine, and reproductive functions of a participant. So schools must make reasonable modifications to provide equal access to program benefits because people have different needs. A reasonable modification is a change or alteration in policies, practices, and/or procedures to accommodate a disability that ensures children with disabilities have equal opportunity to participate in or benefit from a program. This generally includes substituting menu items with nutritionally equivalent components, but that's not always the modification that needs to occur. Medical statements to support requests for meal modifications are required only when the modified meal does not meet the program meal requirements after that change. Medical statements from doctors, nurse practitioners, physician's assistants, and registered dietitians are acceptable. Medical statements at minimum have to include information about the child's physical or mental impairment that is sufficient to allow the SFA to understand how it restricts the child's diet, and an explanation of what must be done to accommodate that child, and the food or foods to be omitted and recommended alternatives if appropriate. The SFA's responsibilities include letting parents know that there are no additional costs that come with a meal modification. However, parents may elect to contribute in some way to the requested modification, like sending soy milk to school for their child. Provisions for meeting special dietary needs should be included in contracts with vendors and food service management companies. Food service is not required to provide the exact food substitute as listed on the medical statement. SFAs should continue to provide some form of reasonable modification even when there is some disagreement with parents as to the best course of action. Be aware on substitutes that exact substitutes are not required, but you must ensure why the specific substitution was recommended to make sure that no harm is being caused to a child by an alternate substitution. So, any program participant may request a special diet or meal modification for reasons other than disabilities, such as lifestyle and religious preferences. Schools are encouraged but not required to make food substitutions for non-disability requests. Meal modifications made for non-disability requests must meet the USDA meal pattern requirements, though, and can, in many cases, be managed by using offer versus serve and/or by providing additional food selections in each meal component category. Note that many previously identified non-disability meal modification requests, such as requests based on food allergies, would likely now be considered to be disabilities under the expanded definition. Communication with families is imperative in this process of identifying and implementing necessary meal modifications. Procedural requirements around requesting meal modifications include developing a procedure for requesting modification, having information about requesting that modification posted on your website, ideally beside program information, training appropriate staff, appointing a 504 coordinator to handle civil rights issues, and consider assembling an implementation team. Procedures for requesting modification must meet the following criteria. Provide notice of process for requesting modification, decisions on requested modification, and procedural rights to appeal decisions. Providing families opportunity to examine records relating to accommodation decisions and the right to file a grievance. Providing for an impartial hearing and reviewing the process for appeal. Note that the USDA non-discrimination statement must be included on procedural information, especially if an adverse decision is made. Best practice would be to make the process for requesting a meal modification part of the regular school lunch breakfast information that's given to parents or again posted on the site. Sponsors should consider working with the food service department to develop a game plan for accommodating the 9 most common food allergens. Please remember that individuals may require additional consideration and modifications outside of the established plan. Because every case is different, open a line of communication with families when trying to develop an appropriate modification plan, and avoid imposing personal biases and experiences on modification decisions. The 8th element of civil rights training is language assistance. Recipients of federal funding have the responsibility to take reasonable steps to ensure meaningful access to their programs and activities by persons with LEP or limited English proficiency, also defined as individuals who do not speak English as their primary language and have limited ability to read, write, speak, or understand English. Volunteers may be used as interpreters to assist LEP individuals, but must be aware of interpreter ethics requirements, specifically confidentiality. Children should not be used as interpreters. LEP services should be able to provide on a local level in a way that demonstrates consistency and competency. Service cannot be delayed because a sponsor is unable to provide the necessary services. An example of that would be a translator who only works part-time and won't be available until next week. A participant may elect to bring their own interpreter or translator as long as both the participant and the sponsor are comfortable with the arrangement and the participant understands that they're not required to provide their own language services. Language assistance is a part of having a public notification system that's effective because you can't only inform some of the population about meal programs. The SFA is responsible for making sure that program materials are available in the appropriate language to ensure meaningful access for all participants. Determine the language needs in your community. Provide notice of reasonable accommodations and language assistance in the notification letters to families about the school nutrition programs or on the website notification with the other school nutrition program information. Free and reduced applications or menus may need to be translated. Providing Braille or large print documents for visually impaired participants are other examples of language assistance. Providing translated information and notices of availability of free auxiliary aids and other services for individuals with disabilities and language services for those with LEP are offered at no cost to the applicant or participant. A shortage of resources does not eliminate the translation requirements. So some best practices if you don't have a lot of resources around translating documentation include sharing resources with other districts, using an interpreter from other programs, training bilingual staff to be interpreters. If you do that, please be mindful of labor rules when engaging them to act as interpreters. Utilize language line phone services, and getting support from grassroots organizations that have a lot of great resources. The ninth element of civil rights is customer service. Good customer service will help reduce or eliminate complaints of discrimination. Each time that you interact with program participants, ask yourself, how would I want to be addressed? Am I treating this person in the same manner that I treat others? Have I informed this person of exactly what information I need to make a determination on this application? Have I given this person the opportunity to clarify all relevant factors and ask questions? Have I provided this person with needed information to make necessary decisions? And we have a must-do list to summarize those 9 elements of civil rights training we've gone through in this presentation. So offer all child nutrition programs in a non-discriminatory manner. Train staff annually on civil rights. This includes food service and other district staff with program responsibilities of any kind. Develop and fully implement your civil rights complaint procedure, including specific steps for the reporting of civil rights complaints to RIDE and FNS. Develop and communicate a policy for requesting meal modifications. Make civil rights complaint forms, logs, and complaint procedures available to all staff. Prominently display the And Justice for All poster that's most up to date. Use the full updated non-discrimination statement on all vital program materials and the shortened non-discrimination tag on other materials such as menus. Other materials beyond menus have to be approved through RIDE. Also, offer meals to all students present in the school at the time of meal service without discrimination. So whether you have an upcoming school nutrition program administrative review coming up or not, this list lets you know what concrete documentation we're looking for when we come on site that applies to these 9 elements of civil rights training. Thank you so much for sitting through the entire civil rights training with my shaky voice. If you have any questions, please contact any one of us on the next slide. Thank you.